This case is a slow-motion car crash wrapped in legal arguments, questionable judgment, and a defendant who simply cannot stay away from substances no matter how many chances he gets. Today's hearing revolves around Mr. Barnhart, a man standing in front of the court on what appears to be his fourth and fifth OWI cases, with another one waiting for him in Wayne County. If you think that sounds outrageous, buckle in because it gets even more wild. We have a judge who has clearly seen enough, a defense attorney hanging on to the thinnest legal thread available, and a bond violation report that might be the final nail in the coffin. And here's the kicker. The defendant tested positive for cocaine, THC, benzodiazepines, and Suboxone within days of being released. The question is whether this counts as a bond violation or whether he used just early enough to avoid punishment. We're about to watch attorneys debate everything from drug detection windows to public safety risks, while the judge tries to determine whether this man is a danger to the community or simply battling addiction without putting anyone at risk. As you listen, ask yourself, is he genuinely trying to turn things around, or is he one bad day away from another incident behind the wheel? Let's get into it.
So you're arguing to me that with all, this is legitimately 4 and 5, with another one pending in Wayne County, and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, Assistant Public Defender Ben Denowith on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report in receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone.
Right here is where the tone of the hearing shifts. The prosecutor is laying out a powerful argument. Even if the drug test doesn't technically qualify as a bond violation, the defendant's pattern of behavior still screams risk. Multiple OE charges, a history of substance abuse, and now a fresh positive test make it hard for any judge to believe this man is stable enough to remain free without restrictions. This is also the point where both sides are playing a bit of courtroom chess. The defense is trying to argue technical details like timing of use, drug retention windows, and testing gaps, but the prosecution is looking at the bigger picture. They are saying, forget the technicalities, look at the pattern. And that's what you should ask yourself. If someone has this many impaired driving cases and substances keep showing up in their system, is technical timing enough to outweigh public safety concerns? Let me know in the comments.
I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check XJail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine I'm less certain of, with extremely heavy use. Maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
can I have just a second, Your Honor?
Sure.
So Yeah, I just think there's possibilities that he's not used after being arrested. And
What?
cocaine could stay in his system for up to a week if there's heavy use. So the failure,
Let's say, well, I don't know, a week.
This moment is crucial because the judge is signaling something big. When a judge questions whether the bond was appropriately set in the first place, that's a red flag for the defense. Bond isn't just about showing up to court, it's about ensuring someone isn't likely to harm others while their case moves forward. Here, the judge is reading between the lines. Even if the cocaine test timing is debatable, you still have someone with multiple OWEs who seems unable to stop using substances. Judges look for patterns, and this defendant has left a breadcrumb trail of risky behavior stretching back years. Notice how the defense tries to pivot away from danger and toward alternative explanations. That is classic defensive strategy, shift from public risk to technical ambiguity. But judges care more about community safety than loopholes. If you were the judge, would you buy the defense's argument or lean toward revoking bond? I'm curious how you'd interpret this one.
But let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have two in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these two cases. There's the other one in Wayne County. He's got priors and he's still using.
I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
This is one of the most intense statements a judge can make in a bond hearing when she says, luck's going to run out. He's going to get behind the wheel and he's going to take somebody out. That is courtroom language for, I've seen this movie before and it never ends well. Judges rely heavily on experience and pattern recognition. They see hundreds of impaired driving cases, and they know how fast things can turn tragic. While the defense claims he has no access to a vehicle, the judge isn't buying it. Judges have heard the "I don't have a car" line from countless defendants who still find ways to drive. The question she's wrestling with is simple. Does she risk public safety by keeping him out? Or does she increase restrictions to prevent what she believes is inevitable? Let me ask you. If someone has years of OE history and continues using drugs while facing new charges, is no car enough reassurance?
I don't have a vehicle. Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, You're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. We don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I make that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is.
Here, the prosecutor lands the strongest blow of the entire hearing. She outlines a timeline that is almost impossible to argue with. OWI convictions in 2002, 2004, and 2016, plus 3 more cases between 2023 and 2024. That is not a coincidence. That is a documented history of impaired driving spanning more than 20 years, and the cherry on top, a blood alcohol content above 0.30 in both recent cases. For context, a BAC above 0.30 is dangerously close to life-threatening. Most people would be unconscious or hospitalized. The fact that he was allegedly behind the wheel at that level is staggering. At this point, the debate shifts from, is he violating bond, to should he even be out on bond at all? The prosecution is telling the judge, this is exactly the kind of defendant bond restrictions are meant for. What do you think? Is the prosecutor being fair, or does addiction deserve more leniency?
People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set, because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. So you're waiving your right to preliminary examination in these cases? Yes, sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution.
Sir.
People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
Sign the
It
form
might
to
have been
waive after this.
PRs, $25,000 PRs, but I
There, I have on each of these that they're PR.
oh, I apologize, Your Honor, my mistake.
This hearing ultimately comes down to one theme: risk. The defense argued technicalities, drug detection windows, and the lack of clear proof that the defendant used substances while on bond. But the prosecution brought something far more compelling: decades of impaired driving history, dangerously high BAC levels, and multiple new OI cases in a single year. The judge balanced those arguments and decided that the safety concerns were too great to ignore. She increased the bond to $25,000 cash or surety, moved the case to circuit court, and made it clear she wasn't willing to gamble with public safety. Cases like this remind us why bond decisions matter. They are not punishment, they are protection, and when someone repeatedly drives under the influence, a court must consider the worst case scenario because it has happened too many times before in too many courtrooms. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with good time.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may. What was that date again?